When I saw this question, I was on fire because it's actually a subject really near and dear to my heart. And this is what I wanted to say about this hocus pocus about, how the rule is 20 minutes. When I go to a car dealership and I want to buy a car, they let me look at the car, they let me ride in the car, they let me stroke the car. They want me to see the car because they're banking on the fact that the more time I spend with the car, the more likely it is I want to buy it. Okay, now that's not exactly the way the district is showing you their classroom. They're actually doing the exact opposite. They're banking on the fact that the less you see, the better. So there's been an evolution in this area, a really, really interesting evolution. It started out that if you wanted to have a classroom observation, but you'd already filed for due process, the hearing office would say no on the grounds that you only wanted the observation for purposes of the due process hearing and not because there was any chance that you were actually going to accept the placement. And so in the old days, we could file for due process. It wouldn't immediately go to hearing. We would try to get the classroom observation and we'd be shot down. So in, I think, 2005, we had a kid in the Long Beach School District, and he was not eligible for special education. He was a high-functioning autistic young kid, and his family was in Long Beach. So we approached Long Beach and asked them to assess him for eligibility. They found him eligible, and they offered him a classroom placement in an emotionally disturbed class in the Long Beach School District. Well, this has been over the course of several months, and so by this time the parents had privately placed him at the Help Group, which is a pretty well-known California program for kids with autism. So the district offers this classroom, and we have to look at it to determine whether or not it's a suitable placement, because if it is, obviously we can't go to hearing and win. If you privately place the kid, you have to show that the district's program was inappropriate as well as that the program you picked was appropriate. So we asked to see it, and they said no, citing the old rule about, the fact that you couldn't request an assessment like this if you'd already filed for due process. So we decided that we wanted to litigate the issue, and so we filed a lawsuit. And we lost at the trial court level, but we won on appeal, and what we ended up with was a case that substantially rewrote the observation statute in California. So the case it's very, very interesting case, and I don't think it's interesting because it's my case. I think it's interesting because it was an interesting issue. So the case is called Benjamin G. versus Special Education Hearing Office, and if Shannon wants to make it available to people later, we'll get a copy to her.
Okay.
But essentially, the court went back and looked at this question of whether you should be entitled to have an observation, even if it's for purposes of having your expert testify at hearing in a due process hearing. And the court said some very interesting things. These are people that don't really do special education, but they boned up on it, the Court of Appeals in California. And they came back and they said, running through is this idea of parental participation at every step of the process. And, parents are at a disadvantage because the district knows more, and basically the family has the burden of proof, blah, blah, blah. So it would be very important for the family's own ability to participate at hearing to have this expert assessment. And so even if the only reason you want it is so that your expert can testify at hearing about the suitability or lack thereof of the district's offered placement, we think that's a perfectly good reason. And then the district had thrown out another argument, which was that if the court did decide an observation was indicated in some cases, that should only be when the district did agreed to an independent educational evaluation at district expense, whereas in our case, we weren't trying for that. We had just hired a private person, and they came back and they said that doesn't matter. So shortly after Benjamin G., California Education Code 56329 was amended to conform with this decision. And so essentially, the rules on classroom observation are now codified there in California. And I'm cheating, I'm looking at the statute, but basically what it says is if the district did an observation, or, and this is really important, has a policy that allows for in-class observation of a pupil, then you get an equivalent opportunity to observe whether it's an IEE or a private evaluation. So that's really good for us because if the districts screw around and they don't allow an observation, we can make a motion to compel the observation under this section. So it's really been interesting because they still fight us on observation. They don't like them. They don't want us to see. They're not confident that they'll be able to persuade, the expert that it's an appropriate program. And so they still fight us on it, but we have a lot more in our quiver now in terms of fighting back. So the language in Benjamin G may be very interesting to parents in terms of seeing how the court talked about this whole, idea of process and parental participation. What Benjamin G didn't anticipate, or maybe they did, but these things tend to be decided on narrow grounds, was the sneaky ways that districts would try to get around the new rules on observation, and they do it a couple ways. One, they invoke this 20-minute rule. Well, the 20-minute rule is based on their visitor policy, usually, that says that, when parents come to visit the classroom, they can't be there more than 20 minutes. This is not a visit of that sort, and it's controlled by either in California, Benjamin G, or 56329 of the Education Code. 20 minutes has no value in hearing. It has no probative value whatsoever. It's useless. Don't do it. And along those lines, if an expert observes for less than 90 minutes, I don't think that it's particularly useful either. So you have to insist on 90 minutes. Now, when you insist on 90 minutes or 2 hours, they're going to come back and they're going to say, yeah, we want you to do it on successive days. And that stinks because that means the expert may have to drive 6 additional hours or something, depending on how far away they are, adding much expense to the parent's tab. And so that's a form of harassment, and it should be fought back against via a motion or via, a strongly worded letter or whatever. I'm actually having a call this afternoon because I have a dispute with the district. They're saying that the expert can come for 90 minutes, but she has to do it on 2 days. And as your person pointed out, you may need longer in order to figure out really what's happening. If you chop the day up into little 20-minute increments and make somebody come back 5 times, it's entirely possible that they won't see much of anything, and that's the idea. So a practice tip would be when you go to the IEP, before you request your observation, if they've recently done an assessment, you get very detailed answers from them about how they assess, where, how long, was it 1 session, was it 5 sessions, and you nail them on the amount of time they spent. And then when you ask for your observation, you remind them you're entitled to an equivalent opportunity.
Ooh,
so,
I love that.
You can see I'm all fired up about this topic because of the basic unfairness of it. And then there's one more just little aspect, another level of this, which is we've been asking for years when they come back and they say, get rid of the card program, it's not necessary, we can use the district aid. We say, great. So that's an aspect of placement, because placement is defined by facilities, location, and personnel in California. Let us see this aid that's going to be primarily responsible for the student's education. If they're going to be with them 40 hours a week, we deserve to look at the aid. And believe me, we get into some very hot discussions about that, because you think the districts want us to come observe their aid, have an expert observe their aid,
Yeah.
no such thing. So that's observation. You always got to see. You always got to get somebody in there to see the classroom. You don't know what's going on until you do.